Okay, I want to thank everyone for joining us this morning for our third vaccine-related webinar of the week and our fifth in our vaccine series. I'm having some sketchy PowerPoint behavior this morning, so I'll wait to the end to address any Q&As, but you guys can go ahead and submit any questions you have, and we'll do our best to answer them at the end or after the presentation. And if you miss anything or just want to hear my lovely voice yet again on this topic, you can find those slides at the website that you're seeing on your screen right now. All right, so today, again, as I mentioned, this is going to be the fifth part of our COVID-19 vaccine series. We're going to address HR risk management for healthcare employers this morning. The last couple of days, we've kind of talked to a broader audience, and today we're going to kind of get pretty specific for our healthcare clients. Well, you can see our agenda here. We'll start off with some HR issues. Now, we addressed a lot of these yesterday, so I'm not going to go into quite the same detail that either Rebecca did yesterday or that Sarah did about a month ago at this point, back in December, on issues like mandating and incentivizing. But I'll cover those again in case you guys did not address those, or in case you were not able to join us yesterday. After that, we're going to jump into risk management issues. We're going to discuss in some more detail liability and immunity. And again, that's something we discussed, but we kind of talked about at a higher level yesterday. We'll get into a little bit more detail on the PrEP Act. And then we'll also address, which we really didn't get into yesterday, some state immunity provisions that might apply to healthcare providers that are administering the vaccine. And last, but certainly not least, we'll address some HIPAA and confidentiality issues. We'll talk about a recent announcement from the Office of Civil Rights on the HIPAA issue. All right, so let's jump right in here, the HR issues and the vaccine. So one of the issues, obviously, that employers of all types, and including healthcare employers in particular, are considering is whether or not they should mandate the vaccine or let it be voluntary. And Rebecca kind of mentioned this yesterday, but we sort of try to keep our finger on the pulse of what employers around, particularly West Michigan, but even around Michigan more broadly are doing. And so far, it seems like the consensus is most employers are not mandating the vaccine, and that's true even of healthcare entities. Again, people should be, especially healthcare entities, should be pretty familiar with the mandating versus voluntary aspect of vaccines when it comes to the flu vaccine. There's been plenty of guidance. It's something we deal with on a regular basis here at Miller Johnson. But just to kind of go over this again, vaccine is not a medical exam, so private employers can mandate the employees receive the vaccine as long as, again, as is usual in the legal field, there are some caveats or some exceptions and considerations. If the vaccine is mandatory and provided by the employer, the screening questions are covered by the ADA. So this is particularly common with our healthcare clients because, again, they're the ones that, so if they're administering the vaccine to their own employees, they're going to be required by the emergency use authorization to provide certain facts about the vaccine, and they're also going to be required to ask some screening questions to evaluate whether it's appropriate for the person to receive the vaccine. So, again, questions about allergic reactions to prior vaccinations, that sort of thing. So if you're administering the vaccine to your own employees, then that is going to be, those questions are going to be covered by the ADA. And so in that case, those must be job related and consistent with business necessity. Employer must show that it would be a direct threat to the employee or others not to receive the vaccine if they're going to be mandating it. So in this situation, I think there's a pretty compelling argument. Again, we don't have clear 100% guidance that this is going to be considered business necessity, but there's obviously a strong argument here that an employee who is not vaccinated is able to contract COVID-19 and is able to spread it to patients that would be, or to or to other employees. So in that case, that would be the argument for a direct threat. I think perhaps the counter argument would be is it's not clear at this point whether or not the vaccine does in fact prevent the transmission. There's strong evidence the CDC and the pharmaceutical companies have shown data that seems to support the idea that it helps prevent people from getting sick, but the testing and the data around transmission is less clear. So that would be the counter argument. But again, there's certainly an argument there for business necessity. With respect to proof of the vaccination record, obviously that's something that in particular our healthcare clients are going to be interested in. Is a given employee, have they been vaccinated, especially if you're not going to be the ones administering it, people can get it elsewhere. So employers can request proof of the vaccine. There's nothing illegal or there's nothing that prevents employers from doing that. And then we would recommend that you maintain that in the confidential employee health file. And this is something that healthcare employees, with their experience with HIPAA, many healthcare employers offer health plans. So again, keeping these documents separate under HIPAA, which we're familiar with, and we will discuss it here at the end of the presentation, is something that you guys need to do as well. So potential accommodations, obviously, anytime we're discussing the ADA, you must consider ADA, and also when we're talking about vaccines, religious accommodations. So, again, this is something that our healthcare employers should be pretty familiar with due to the flu issues and the sort of annual process. So it's important to have an accommodation process ready to go, whether that's requiring people who refuse the vaccine or are unable to receive the vaccine to wear masks or other PPE. If employee has a legitimate disability or sincerely held religious belief, analysis will turn to that direct threat analysis that we discussed before. Pregnant breastfeeding employees should also not be mandated and must consider accommodations, as I just discussed, if an employee refuses to get vaccinated. So again, you can, there on our screen, there's, I encourage you all to check out our webinars on December 18th and just yesterday for some additional analysis on that. I'm trying not to double dip too much here. All right, so another real common question that we've received over the last week or two in particular are questions about incentivizing the vaccine. What can we do to encourage employees who are hesitant to receive this to get the vaccine? So there's a variety of things you can do. So, one is a communication campaign providing, answers to FAQs. There's a lot of resources that the Michigan Department of Health and Human Services has provided out that employers can print out. You can communicate that leadership, by setting a good example, is getting the vaccine. You can also go to vaccinatewestmichigan.com. There are additional FAQs there, flyers from Kent County Health Department. Again, legal options for incentivizing the vaccine. One of the main consideration here is that you have to be careful not to cloak a mandate as an incentive. And there's no clear guidance on this particular issue as to where that line is exactly drawn. If you're considering different incentives, we encourage you to contact, your usual Miller Johnson employment attorney, or contact me as well to discuss, where that line is, to talk over your different options. If the incentive is large enough, then it is possible that it might be seen as coercive and kind of tip into that mandate, which raises additional issues. Again, it's not strictly prohibited, but it might raise additional issues. Again, another option that we're seeing, a number of companies have announced this, is PTO for missed work time to get the vaccine. And again, there's no longer pay for COVID-19 related absences at this point. And again, feel free to, Rebecca talked a fair amount about this yesterday, and encourage you to check that out for some additional analysis and details. So here's just a couple examples that I've seen in the news with respect to incentives to encourage employees to get vaccinated. There was a Houston health system that paid $500 as what they called a hope bonus So this sort of the marketing or the message with respect to this bonus was that it was for was sort of another bonus. They had done bonuses similar to this earlier in the year for kind of a difficult year. Obviously, in particular for healthcare workers, it's been a very stressful and difficult time. Oftentimes, hospitals have become overwhelmed with COVID-19 patients. And there's obviously just kind of uncertainty on their own as far as working in that environment and the risk of contracting COVID-19 themselves. So this bonus was paid out ostensibly or in part for that, but in order to get that $500, there was a requirement that the employee had to be vaccinated. Another one I saw was sort of a raffle prize. So, you have a number of prizes. Anybody who gets vaccinated becomes eligible, and then there's some sort of drawing to get that prize. More recently, Trader Joe's, Instacart, and Dollar General are some of the larger companies that have come out and said they're going to be offering incentives to their employee. Instacart offered a $25. Again, I think, when you talk about that $500, I think, that might be getting closer to the sort of coercive amount of money. I don't think $25 is much of a risk on that level. For Trader Joe's and Dollar General, they've offered PTO. And again, this is getting outside my area of expertise, but there are Fair Labor and Standards Act considerations to think about when offering PTO and overtime. You have to think about whether or not that is overtime. I believe Rebecca said yesterday that it would in fact be considered, have to go into the overtime consideration. Again, I encourage you to reach out when you're considering these different incentives. Reach out to, a Miller Johnson attorney, and they can talk over the pros and cons, the risks, and we can also maybe provide insight into what some other employers around the state of Michigan and West Michigan in particular are doing on that front. One thing to consider is, particularly if you're offering a large incentive, is what is the message that you're sending by doing so. I've seen a number of articles, if you're offering a lot of money or some other significant incentive, is the message that's being sent to employees that, hey, this is risky, and so we want to offer you something so that you'd be willing to take that risk. So I think anytime, there's messaging around the importance of getting vaccinated or encouraging people to get vaccinated, it's important to consider, be very careful in the language that you're using. You got to think about if you will pay the incentive the other issues are, you need to think about, all right, so, we had a first round, all the people that were willing to take the vaccine took it. There's some employees who are, still being cautious about the vaccine. So let's offer an incentive. How is that going to be met by the people who already received it? Do you want to offer that incentive to people who already did receive it? And I think the answer is that you can do that. But again, these are considerations that you want to think about and talk over internally. Again, think about timing of the incentive. Are you going to, this is probably a little late for healthcare entities. They've already been administering the vaccine to lots of employees and have been for, a little over a month at this point. But, if you're discussing holding clinics or talking with other outside employers, you want to mention that with them as well, the timing of any incentive. And again, as I mentioned before, it's important to think about the messaging and all of this communication as far as you don't want to make this seem like there's some risk or there's some reason why they wouldn't want to do this and that you're trying to coerce them in any way into getting the vaccine. All right, another question that we received over, the last month or so relates to volunteers and vaccine administrations. Obviously, there's, our healthcare clients are still seeing regular patients. Hospitals are, performing procedures. And so now they have, on top of this, they're trying to vaccinate the general public and their employees. That can obviously put a crunch on staffing type issues, especially if, thankfully, the surge has died down a little bit here. But if you have a number of employees who are sick, trying to balance all of that can be difficult. In addition, a number of sort of either retired or semi-retired healthcare workers have stepped up over the last year in helping out hospitals and other healthcare providers and volunteering. So that raises issues of volunteers. So one of the issues is that you can't really have your own employees volunteer to do a job they're otherwise paid to do. So if you're running a vaccine clinic and you have a nurse or a physician or some other employee who's willing to sort of man that clinic and administer the vaccine, then you can't really have them volunteer and have them do that for free, which is unfortunate because, as we'll kind of get in later, volunteers are generally it's easier to get immunity if you're acting as a volunteer. What about non-employees who want to volunteer? Again, this can be a tricky issue as well. It can sometimes be problematic to have a volunteer do something that you're also paying one of your own employees to do. So you have, nurses who are getting paid to administer the vaccine, standing side by side with, volunteers who are doing the same thing. Again, one of the things we've done over the last year or so is try to not let legal issues get in the way of helping people, treating people, or in this case, administering the vaccine. So please reach out to someone like Rebecca Strauss or your other healthcare employer expert on here at Miller Johnson, and they can help you make sure you get the right forms in place. Make sure they have health screenings. Another issue, make sure that they still have license, make sure they aren't excluded from any sort of Medicare or Medicaid programs, those sort of issues. And so make sure that you're in compliance when you're using these volunteers. All right, kind of moving on from the HR issue. Again, if I kind of breeze through a couple of those a little too quickly for you, I encourage you to check out one of our prior vaccines on this issue or contact your Miller Johnson attorney. All right, so we're going to discuss, vaccine distribution. In order to receive distribution of the vaccine, providers, healthcare entities are going to need to sign a provider agreement. This is all done online via the Michigan Department of Health and Human Services. There's a couple of forms with information you'll have to fill out. You'll have to have a medical, your CMO, provide their information. And then ultimately what you're going to be doing is agreeing to a provider agreement with the CDC and the state of Michigan. The very first term on that is that providers must agree to comply with the ACIP recommendations. Now, for those who were not able to join on Tuesday, we went over what those ACIP recommendations are and the various phases. We talked about phase 1A and B and all of those, and phase 1C and the different sub-phases within that for the different ages. And I want to highlight this for a couple reasons. One is because, if you fail to follow those recommendations, and also make sure you're monitoring the state because there can be some slight deviations, then you could be found to be in violation of your provider agreement, which obviously is not something we want to do. The other thing is, I suspect, particularly as this goes on, that there'll be increasing pressure on healthcare providers and more questions about, who is eligible? Can I move in? People wanting to cut lines. We've seen some stories about that already. And so this will provide some leverage for you to say, no, look, we can't. We sign a provider agreement that says we have to follow these recommendations. We can't deviate them at all. Another thing, providers will be required to report information to the state, and that'll be through the MCIR. That's an electronic reporting. You'll have to do that within 24 hours of the vaccination, and there's information at the Michigan Department of Health and Human Services. There's a whole webpage for providers and talking about vaccine distribution and administration, and there's information on how to enroll with that and the reporting obligations you can find there. Providers also agree not to sell or seek reimbursement for the vaccine. Again, so the vaccine is being provided by the government. They purchase it directly from Pfizer and from Moderna, and then hopefully soon enough from Johnson & Johnson and other pharmaceutical companies that are closer to getting approval. So providers are prohibited from selling or seeking reimbursement. You can, however, charge a fee to administer the vaccine. We'll talk a little bit more about that in one of our other slides as well. Another important issue is you must administer the vaccine regardless of ability to pay. If someone is uninsured, or then you still are required to administer the vaccine to them, and there's a way you can get paid for that sort of uncompensated care as well. Again, potential penalties for breaching the agreement is the inability to receive future vaccine distributions. They could terminate sort of that provider agreement, and then the provider would no longer be able to get vaccine. And then there's fines, criminal charges, and potentially a False Claims Act case is one of the things that they identified there. Again, you're making representations by signing this agreement that you're going to comply with these various terms. And so, and in exchange, you're receiving these vaccines free of charge. So I think that's the hook for it to be a potential False Claims Act case. Again, so here's the actual agreement that you'll see. You can see, the information that you have to provide, responsible officers. And then here are the specific terms related to that. And again, so it says, if you look at the third one, organization must not sell or seek reimbursement for COVID-19 for the syringes, needles, or other constituent products and supplies that the federal government provides without cost. Again, you all are probably more familiar with this than I am. There's significant and difficult storage issues to get around with these vaccines that need to be kept very cold, but not too cold, and that sort of thing. So the costs related to that cannot be passed on or charged to anybody. Can't seek reimbursement for, the dry ice that's provided by the government. And so, one of the issues that we've heard asked by both healthcare and non-healthcare entities relate to, okay, so what's our liability and immunity if we're holding these vaccination clinics, if we're administering the vaccine? And, the good news here is that there's a number of statutes, both federal and state, that potentially provide immunity. And kind of the biggest one that we keep discussing is the PrEP Act. It provides immunity for the administration of countermeasures, provides immunity to manufacturers, distributors, program planners, and qualified persons. The program planners would be, if recently St. Mary's, Spectrum, and Kent County Health Department announced that they're going to eventually have, as vaccine supply increases, a clinic at the DeVos Center here in Grand Rapids. And so, they would almost assuredly qualify as program planners who are kind of administering and managing that clinic. The qualified persons are typically licensed healthcare providers. So again, the physicians, the nurses, the other staff members who are administering and operating the clinic itself would also likely be provided immunity. Again, I'll get into a little bit more detail about the PrEP Act on the next slide. But there are other federal immunity that might be available as well. The CARES Act provides immunity for provision of healthcare services as a volunteer. So, while we discuss the difficulty of volunteering for your own hospital or health system or employer, it's possible to volunteer for the local health department if you're an employee, if you're a healthcare employee. Again, that provides immunity to volunteer healthcare professionals. And lastly, there's the Federal Volunteer Act, which volunteers of nonprofits and governmental entities. That one's, I think, probably a little harder to make out under most of the circumstances that I'm seeing the vaccine be administered, but that is potentially something to consider as well. Again, there are some limitations to immunity, but they are, willful misconduct, criminal conduct, gross negligence. So, regular negligence, or even in most cases, sort of reckless acts will still be immune will still provide immunity to entities and individuals under most of these acts. So getting into the PrEP Act, again, one of the key things is an approved countermeasure may include medical product used for COVID-19 that is approved, cleared, or licensed by the FDA or authorized by a EUA, emergency use authorization. And again, so that it would include quite clearly the vaccine, which is the focus of today, but it is not limited to the vaccine by any means. There's antiviral drugs, certain respiratory protective devices would be provided immunity as well. Covered, so again, it has to be a countermeasure used or administered by a covered person. So I mentioned this before. Here's a little bit more detail, specifics on the program planners, entities involved in planning, administering, or supervising programs for distribution of countermeasures. So again, I think this is where, to the extent that you're cooperating with another healthcare entity, having some sort of agreement or memorandum of understanding where you identify that, our tasks or one of our responsibilities is to assist in the planning, administering, and supervising of this vaccine clinic. Again, that will make it quite clear that you would meet the definition of program planners. Qualified persons, again, are also immune, and those are people who are authorized by state law to prescribe, administer, or dispense the countermeasures. So with respect to volunteers, again, that's something we've discussed a couple times now. You want to make sure that they still have their valid license and certifications, because the qualified persons, again, one of the key elements to be a qualified person is that you're authorized under state law. So if someone has a lapsed license or other training that is required by state law, then they would not meet the definition of a qualified person. And there would also, for that matter, potentially using unlicensed people might also raise issues with respect to, receiving compensation for the administration of the vaccine. Other elements, the claim must be for a loss, and the loss must have a causal relationship with the administration or use of the covered countermeasure. Again, so, and it must pertain to prescribing, administering, licensing, or using a covered countermeasure. And I think, I do want to emphasize that, as I kind of first read the PrEP Act, I was like, I don't know, there's a lot of terms and a lot of requirements here. What is that causal relationship? That's something that's argued about in basically any negligence type case. But there's been some guidance and some case law, I think, that is beneficial, that shows that these terms are going to be interpreted pretty broadly. Again, at least with the vaccine, it's quite clear that anybody administering the vaccine there's going to be, that would be, anything related to that that's connected to that really in any way is going to be prohibited. They're not going to be able to sue over that. You'll have immunity. So there's not a whole ton of case law on the PrEP Act. There's a few different cases out there that relates to nursing homes being sued is kind of the main area where we've seen some case law in this area. And those are situations where generally either a resident of a nursing home or the family of someone who unfortunately passed away at the nursing home as a result of COVID-19 have sued a long-term care facility of some sort. And there's been a couple situations where courts have said, no, PrEP Act does not cover you for the allegations made in this case. For example, court said, simply using countermeasures somewhere in a facility does not preclude all claims. The fact that some staff were using PPE or some steps were taken, some covered countermeasures were used, does not mean that the facility is entirely immune. The big takeaway really is, the failure to act is not going to be covered. If you look at the PrEP Act, the focus is on the administration or use of a covered countermeasure. So failure to do that. There was a case back with H1N1 where a hospital elected not to administer a vaccine to an individual who eventually, I believe, passed away from H1N1. And the court said, you decided not to do that, and so that's not an administration of a covered countermeasure. So kind of the takeaway there is that the failure to immunize may lead to a lack of legal immunity. So again, what I want to stress here, though, is that an individual's refusal or decision not to be vaccinated, would not lead to a healthcare provider losing that immunity if it's the individual's decision. In that case involving the H1N1 vaccine, that was the decision by the healthcare providers not to give the vaccine in that situation. HHS has also provided some guidance, and I think, as my lawyer mind was going and talking with clients about these clinics, what potential claims are there? I mean, there's the obvious, like, what if there's some sort of reaction to the vaccine? It's pretty clear that the PrEP Act would provide immunity related to that. But my mind started going to, okay, well, what if someone slips and falls? What if they have a reaction to the vaccine and then fall and hit their head or get in the car or something like that? And there's been some helpful guidance by HHS that said it precludes claims, the PrEP Act, alleging negligence, management of a distribution program or site, including a slip and fall injury or car accident, connected to that. So it must be directly related to the countermeasure activities at the site. So, if it's a clinic on the site or at DeVos, if there's just someone happens to be there, again, it's not going to provide you immunity for all activities at your hospital, obviously, but to the extent that they're related to coming in to receive the countermeasure, then there's the immunity is going to be quite broad there. And again, so the federal act, well, there's a lot of focus on the PrEP Act in particular, and there's also state law immunities. So in particular for our clients who are, public health departments or employees of the state, there is immunity for employees, agents of state and local governments. The MDHHS, there's a statute that provides immunity. There's local health departments, employees, officers, volunteers, authorized representatives are extended immunity as well. And again, there's a couple things here. Obviously the activity has to be one these individuals are authorized to carry out. So if they exceed their authority, then immunity may not apply. So one of the takeaways I've had from this is that our private healthcare clients may want to consider working with local health department in some capacity in operating their clinics, because that might afford you the argument that you're entitled to immunity. In that case, enter into some sort of agreement where they identify you as sort of an authorized representative to administer the vaccines or operate the clinic in some capacity. Again, these statutes are quite old. There's not a lot of case law looking at them, but, as we engage in these activities, I think it's wise to try and kind of cast a wide net and see if you can, what immunity provisions you can at least provide an argument that you're entitled to seek protection under. Other provisions include providing emergency care. This is sort of like the Good Samaritan. There's actually two different statutes addressing this. One is sort of the Good Samaritan Act here in Michigan, and one's slightly different. Sort of the common elements within these are, the healthcare providers can't have an existing duty to treat these individuals. Again, so, if someone comes to the emergency department, physicians have a duty to treat those people, and so they're not going to be able to get immunity under these acts. And the bigger kind of issue is that individuals can't be compensated for providing this care. So to the extent that employees are being paid and providing these immunizations, they certainly wouldn't qualify under this. Also, in those cases, it's not going to be emergency care, but in responding to some sort of reaction, they likely already have a duty and are going to have it's going to be a hard argument that they're immune under either of those. There are a couple other for immunity provisions for free immunization programs from the local health department and free healthcare clinics operated by, nonprofits or governmental entities. So Again, limited to health departments and nonprofits. I think the big question here, again, there's issues about volunteering and uncompensated, and the question is whether, if it's free to the public, can you still bill an insurance for the administration of the vaccine? And would you, under that, if that's what you're doing, would you be entitled to immunity under sort of the free immunization program provision? And again, it's not clear. There's a very, very old case addressing this issue when the statute had some different language, but I think there's a decent argument there because, as we'll see in a little bit, the public is not being charged out-of-pocket fees for this vaccine. It's really sort of free to them, which leads us nicely into billing and reimbursement. So again, we talked about the provider agreement. There's a prohibition on billing for the vaccine itself, or syringes and other related supplies. Again, as a term in the provider agreement, so you don't want to be breaching that. You can bill for the cost of administering the vaccines, cannot charge patient copays or other amounts. In other words, no balance billing. And again, we mentioned this previously, there's no discrimination permitted based on ability or inability to pay. And there is coverage under, Medicare, Medicaid, private insurers, the VA. There's coverage for the vaccine. Again, this is just going to be for the administration costs, since the vaccine has been purchased by the government and provided free of charge to providers. Again, getting into coverage. So Medicare and Medicare Advantage are covering the vaccine, the administration costs. Actually, depending if there's any Medicare Advantage plans on the line, the payment is coming from Medicare. The plan's not actually responsible for that. With respect to Medicaid, there's no cost sharing at this point because a public health emergency has been declared. I don't anticipate that going away anytime soon. But, as we get closer to sort of the famous herd immunity, I suppose it's possible that CMS or HHS might say there's no longer, I think it's HHS, that there's no longer a public health emergency. And then at that point, Medicaid might be able to charge cost sharing amounts, or they might have to amend their plans to cover those cost sharing amounts that would normally be charged. Again, private plans, the government has issued rules requiring cover with cost sharing, and out-of-network rates cannot be unreasonably low. Again, as a lawyer who has dealt with issues about out-of-network billing, that's a common area where providers might, where there's some disputes. And this term unreasonably low is pretty vague. I think at the very least, it means that the rates can't be less than what CMS is paying, which I think is 16 for the first vaccine and 28 for the second vaccine. So health plans should not be charging less than that, even for out-of-network rates. Again, and I mentioned uninsured. Someone can't pay. If they don't have insurance, then healthcare providers are not permitted to turn them away. What they're instructed to do is to seek reimbursement through the Provider Relief Fund. If you might recall, there's a specific way, there's a number of funds set up, or amount of money set aside for uncompensated care, and providers can use that Provider Relief Fund. HHS has a nice webpage that helps provide instruction on how to do that, or I'm happy to kind of walk you through that if need be. But that uncompensated care, you can get reimbursement for that. So keep track for sure of that. All right, now we get into the HIPAA record keeping and confidentiality issues related to vaccines and COVID-19 more broadly. So the vaccine information is, obviously PHI, and so are COVID tests when administered by a covered entity. I'm really focusing on, this is for healthcare entities. Non-healthcare entities, I talked about this yesterday. If you want to hear about what your HIPAA and confidentiality provisions or requirements might be. Again, be careful with vaccination records of your own employees. This is something we at Miller Johnson talk about quite frequently because, again, we do a lot of HR, employment law work with healthcare entities. it's important we talk about, wearing two hats. You have your provider hat and you have your employer hat. So here, the provider hat cannot share PHI with HR without authorization. So, that's pretty straightforward. It's something that I suspect you all are quite familiar with, but I think it can become a little bit tricky, especially here where it's quite important to know as the employer, which one of my employees are vaccinated. When you're trying to provide education to those who are resistant or hesitant to receive the vaccine, it's nice to know, right, well, what population should I target? And you can't just kind of go over and look at medical records to figure out who that is. Also, I suspect we've already seen this with Meyer, where they're going to be offering clinics to non-healthcare employers. In those situations, when someone's employee comes to your location to receive a COVID-19 vaccination, you need to be careful with those vaccination records. Employers are going to want to know that information. And again, obviously, you can't disclose that as a covered entity. This is PHI, and you can't disclose it to employers without an authorization. So one option is to tell, obviously you'll say no if there's no authorization, but a possibility is to get a authorization if you're holding a clinic up front. You could possibly have the employees sign an authorization that permits you at the end of the clinic to disclose to the employer who received the vaccine. From an HR perspective, you can ask the employee if they've received the vaccine. We kind of mentioned that earlier. There's nothing wrong with that. There's no law that prohibits you from asking. Or another alternative, again, is you as the employer to get an authorization up front or to get an authorization after the fact to determine whether or not they've received the vaccine. You can store that information confidentially in the individual's sort of personnel health file in order to protect their privacy. One question we got yesterday, again, for people who were not able to join yesterday or just wanted to join today because there was some kind of overlap of the issues discussed, was what about employees who are harassing another employee about receiving the vaccine? We've seen emotions high over issues like wearing a mask all the time. I suspect, although I haven't seen any news stories, we'll see the emotions will be high about people refusing to get the vaccine. Again, harassment is not permitted. You would just address that like you would any other harassment or unprofessional type behavior within and among your employees. All right, again, you are required as a healthcare entity to report the vaccine administration to the MCIR. And again, that's certainly permitted by HIPAA to report vaccinations to a public health authority. And importantly, the Office of Civil Rights has said it will exercise enforcement discretion for use of online or web-based scheduling applications. I think one thing that's been encouraging as a healthcare attorney is to see the flexibility of the government on issues like providing telehealth, or allowing licensees to practice across state lines, although most of those have gone away at this point based on sort of state laws. But there's been a lot of flexibility here, and the OCR has said it will exercise discretion if something goes awry with scheduling and there's some sort of breach as a result of that. Again, one thing just to keep in mind is, from an HR perspective, again, even if HIPAA does not apply, you have a proper authorization. You ask the employee about their vaccination status. Make sure that you still keep that information confidential. You're not obviously going to create some big list and post it publicly on the wall saying who has or has not received a vaccine. All right, so just kind of here wrapping things up, we'll discuss some other vaccine-related issues just to keep in mind and to consider as you're moving forward. Some questions, so how do we handle, do we need an order in order to administer a vaccine to an individual? The answer is yes. In my experience, universally, hospitals or, even other clinics have issued a standing order to administer the vaccine. There's a lot of samples online that you can find for standing orders. And so you'll want to document that standing order in the record. And obviously, the fact that someone has been administered a vaccine will be part of their medical record as well. Again, this is important. Excuse me. This is important for payment purposes in particular, and also to demonstrate that you're complying with that provider agreement that you entered into, since only authorized people are allowed to administer the vaccine, and that would include nurses and other staff below the level of physician, provided that there's an order. Again, remember to report all immunizations to MCIR. I believe the requirement is that must be done within 24 hours. I don't think this is a huge issue at this point where providers have extra vaccines left over, but there is a process for redistributing vaccines. You can't just say, oh, we had some extra ones, I'm going to give it to this clinic. There's a redistribution agreement. The other entity to whom you're redistributing the vaccine needs to be have signed a provider agreement and eligible to receive distributions of the vaccine. Again, it's important to comply with the emergency use authorization. You'll see, again, MDHHS has helpful information related to this. There's certain information that must be communicated to patients and caregivers about side effects, that sort of thing. And you also must provide a vaccination card to individuals as well. I think we've all seen pictures and are familiar of that. Social media, lots of people posting their cards showing that they've been vaccinated. Also, there's adverse event reporting requirements that must be made to the VAERS. Always good to include additional acronyms here within the healthcare field. Definitely know we don't have enough of those, but certain adverse actions must be reported through that system. Again, I would encourage people, obviously I'm happy to answer as many questions as you would like to send my way, but MDHHS has some excellent provider-specific resources. They have a nice page. There's a lot of links to CDC, to Pfizer information, to information from Moderna about storage, billing, product information, vaccine administration. There's FAQs that can be used to have discussions with both employees and the public more generally, as I think especially as we start to publicize, well, as supplies and distributions increase and we're able to have sort of larger clinics like the one announced by St. Mary's and Spectrum in Kent County, there'll likely be public communications related to that, and there's some FAQs that might want to be included in that will help sort of maybe alleviate any concerns the public might have about receiving the vaccine. And one other thing, this afternoon, it's not too late to register. There is the Advantage Benefits Group is providing a webinar today at 1 p.m. For those who would like to register for that. There's a link through our chat function. You can go click on that link right now and register. I'm registered and I'm hoping to at least listen in, but there's going to be a representative from the Chief of Scientific and Medical Affairs from Pfizer. There'll be a representative from Spectrum, from the Health Department for Kent County, the Ottawa Department of Public Health, as well as the VP of Meyer Pharmacy will also be available to discuss both, the safety, efficacy, and employee communication about the vaccine, and to provide additional information about vaccine distribution. All right, so there's my contact information. If you all have any questions, I'll kind of scroll up here to look if anyone has submitted any Q&As at this point and try to address those. Again, I want to encourage you to check out our resource center. There's policies there for mandating vaccines, for voluntary vaccines, all that sort of information is available. Something that we're going to be working on that now that I've given 3 webinars this week, I can move on to is kind of pulling together resources and announcements and rules from public health departments, particularly here in West Michigan. And so hopefully we'll be able to get that added up to the resource center. The public health departments are going to be important partners for our healthcare clients in distributing and administering the vaccine, and also in providing guidance regarding who is eligible. And again, just one last plug as far as that goes. We talked about that fairly extensively on Tuesday. So if you want to go back a couple days and review that discussion about who is eligible at the moment. Again, this is also changing quite rapidly, and we're getting different guidance all the time, but my colleague discussed that on Tuesday. And I see, there's one question here about Sarah Willing will also be presenting. I think that relates to, she's going to be talking at the benefits webinar this afternoon. And we'll continue. I'm hoping to issue another client alert to keep you updated on where we are with distributions. Again, there's some interesting announcements with respect to ramping up production of the vaccines that the Biden administration has announced over the last couple of days. So keep an eye out for client alerts. We hope to keep you updated, and as we continue to receive new developments, we'll certainly pull together another webinar. So again, I want to thank everybody for their time, and I wish you guys all a good morning. Feel free to contact me or your other Miller Johnson attorney with any questions you might have.